And we're live. Hello, everyone. I'm Julia Poger. I'm a business, conference, and diplomatic interpreter with a slight cold, just in case you were noticing. I work from Russian and French into English and from English into Russian. And as you probably already know, I also run a business called Know Your Worth, where I help interpreters and most service professionals to understand how to get your name out, how to sell your services, so that you can get work at the fees and conditions that you want. Please make sure to write in the comments where you're listening in from today, because I know we've got a global audience at times for these topics, and this one is a pretty popular one I've noticed from the number of people who have signed up. Before we move into our topic today, I'd just like to ask you to stick around until the end of the show to find out what we'll be talking about next month. So now to today's show. Legal interpreting is an entire type of interpreting that you just can't wing. You have to know certain basics, you have to understand them, and you have to be able to express yourself in different ways. But there's legal and there's legal. And I myself have interpreted for depositions and for local criminal court cases, for international arbitration cases, and for constitutional court cases. And I'm not a lawyer, which means that I've had to spend sometimes 3 days in prep for every 1 day of work that I'm going to do during that job. I have to figure out what I need to prepare and how I need to prepare for that job. So my special guest today is Andrii Biesiedin. Andrii is a legal and conference interpreter, based in Kyiv. After he received his law degree, he became a conference interpreter about 15 years ago. And one of his side projects at the moment is trying to sort out Ukrainian terminology in international humanitarian and criminal law. As you can imagine, he's used to working under high pressure. So let's get to our show. Hi, Andrii. It's good to have you.
Hi. Thanks for having me.
So let's move to our first question, which I hope you can elucidate for all of us, because we all wonder sometimes, what exactly is legal interpreting and where can you perform it?
I would say that legal interpreting is, any interpretation where at least one side is a lawyer. And it's a spectrum, I would say. You can't really define where legal interpreting starts and where it finishes. It's a spectrum between the business negotiations, which slide into the commercial litigation and arbitration. There's also the community service, and there's also the diplomatic interpretation and the political and advocacy. So it's a spectrum. But if one of the clients is a lawyer, then you're into legal interpreting. But sometimes people are just focused on their niche only. I know people who think that legal interpreting is, say, only court interpreting, and that's it. Or that legal interpreting is only interpreting in community settings when you are hired by the state or, well, by the police. If, say, a suspect, if the suspect's mother tongue is different from the mother tongue in the country. And, it's true, this is legal interpreting, but it's really different from all these other niches. So if one wants to really be the universal legal interpreter, you need to know the market, you need to study it, and to know all the niches there. And of course, on top of that, yeah.
No, I was just going to say, it seems really huge, because every country would have their own types of courts as well that you could work in. So the U.S. would have local courts and state and federal and immigration and other things, and then that would differ from what's in, say, France or Ukraine.
Of course, and it adds this extra layer of complexity when you have to interpret from one legalese into the other legalese. Um, some people, they know the, say, English legal language very well. They've read all the Black's dictionary, and they know it like really well. But if the client is a lawyer from the other country, they would have the totally different set of notions even. So it's not just about the glossary as such. It's not about the equivalency of words. You have to know two different legal systems. You have to know how the terms are, I would say, shaped in 3D, because in my mind, they are like shapes. Every notion is like uh, a 3D shape, and sometimes they can't be mapped one onto the other. So the kind of true skill comes when you are able to explain the terms of one legal system in terms of the other one, or explain when you are failing to map it properly. It happens too.
Mm-hmm. And in fact, it could probably even happen between two systems that seem similar and that would use the same language, like the US and the UK, but then you get concepts that would be very different. So, I mean, I'd never heard of a barrister versus a solicitor until I started, watching UK crime dramas and stuff like that. But I mean, that you don't map that onto the US system at all. Before we move on into the other questions, I just wanted to show you how widely spread our audience is. So we have Estonia and Texas and Moscow and Dubai and coming from Tennessee and the US and Italy and Denmark. So we've got a lot of really wide-ranging people here from different
and
situations, and Brussels as
Burkina
well, and the
Faso
UK.
and Egypt.
And Burkina Faso,
Yeah,
yes.
yeah, and
And even
Vietnam.
from my own alma mater, Monterey. So
Fantastic.
so that's pretty cool. So
I'm honored.
it's a lot more complicated than we even know, what legal interpreting is. I mean, it could cover so many different topics. So why don't so can anybody then say that they're a legal interpreter, or do you need some kind of credential
Well, I
since
am a
it's so wide
proponent.
ranging?
I'm a proponent of free speech, so of course anyone can say that they're a legal interpreter, and some people do that. I'm saying that too. But what really matters for legal interpreters is not even having the certificate, not even being able, is not even being able to show that you, I don't know, you tick some item somewhere, that you have some credentials, even though in some markets, in some niches, that matters a lot. Of course, in some niches, if you need to pass an exam to be able to interpret in court, well, most probably this is the only way, even though I can explain later, like it's not always the case. But actually, in legal interpreting, what matters the most is the reputation. So if the clients think you're a legal interpreter, and if other legal interpreters think that you're a legal interpreter, this is what matters the most, I would say, because uh, just calling oneself would not be enough if you don't have the network of contacts, and if the clients don't see your worth as a legal interpreter, I would say.
Mhm. Okay, that seems to make sense. I remember when I was in the States that, and I lived in Washington, D.C., that the credential I needed was something not even legal. It was a certain level of having passed a certain level of the State Department's interpreting exams, which the State Department itself is not very happy to be used as a credential. But the local DC court figured we've got a big organization that's testing people. We're going to use that as our credential. And the level wasn't even conference, it wasn't the highest level. And we were basically thrown into it. And I mean, I knew I had to prepare, but they didn't tell you what to prepare. They didn't tell you anything about it. They just said, we need you for this case and you're going to go. So it was very strange. So one person has already said that they really like your comparison to a 3D model and how you map things onto each other. That seems to work out really well.
And then
I can see that. I do that a lot for terminology as well.
you start juggling. So essentially, it's not just having the shapes, but imagine like it's a little bit of a circus performance. So you really become a legal interpreter when you manage to juggle all the concepts without missing any and without dropping any. And if the audience of lawyers applaud you, well, this probably would be kind of the pinnacle.
That is pretty good. I'm wondering if they applaud you, even if they don't applaud you, if you win the case, if whichever side hired you, because sometimes you're an officer of the court, and sometimes you're actually hired by one of the sides. Is that true?
Yeah. Firstly, I want to say that, of course, no one applauds you in the courtroom, but you might get the nod, which is the legal equivalent of a round of applause. And yes, of course, sometimes you are hired by courts, and sometimes you are hired by the clients. It depends. I mostly have experience in commercial arbitration and litigation where I've been hired by one of the parties, but one of the usually the parties in these cases, they decide who is hiring the interpreters, and the other party is just vetting. They say, okay, I'm fine with that one, yeah, and go ahead. So you might have the contract with one client, you might have the contract with joint instructions from several clients, but it's quite different from being hired by a court because you have the leverage. You can negotiate. You can negotiate even with courts sometimes, or some quasi-judicial entities. And I was surprised when I managed to successfully negotiate with that strong international organization engaged in arbitration. But of course, the leverage is much greater when you talk to a private client, because you can explain your worth, and they are not restricted as much as a public institution.
Mm-hmm. That's very true. So, what makes legal interpreting so different from most other types of interpreting? Why does it scare people so much, or why does it, or why should it scare people so much?
Legal interpreting, I'm I'm a bit surprised that it's, well, it might be scary, but it might be scary if people think of their responsibility and how important it is. But actually, any field of interpretation, I mean, you have to be accurate there too. If you're not accurate, sometimes, yeah, you can kind of, the client would say, okay. Uh, and in legal interpretation, sometimes it matters, especially if you're interpreting in community service, if you're interpreting for a suspect, and there might be a situation when the accuracy of your interpretation would have really serious outcomes for their lives. But usually, I mean, still, there are many safeguards for that. It's not as easy as misinterpreting one word and the person is in jail forever, or like a killer is now walking free. But legal interpreting might be even tricky, because one might think that, well, there are obvious things, and one might use say statements and testimonies interchangeably, because, for example, in Ukrainian, you would, I mean, there's one term for both, so I have to add a qualifier. So it's written testimony, so it's written statement in Ukrainian for one, and the oral testimony for the other. But some people might use them interchangeably and not understand the details. But in all other fields, like in engineering, I might not know the difference between an engine and a motor. I would think that they are synonyms, but they aren't. And just the consequences would, they can also be sometimes pretty significant if it's a multi-billion dollar, or, well, a multi-million dollar, let's say, contract or negotiations, and they end up supplying engines instead of motors, and it was your fault. Well, you're liable too. But overall, legal interpreting requires accuracy, requires sometimes additional skills. That's true, because in the courtroom, you must have some extra skills which are sometimes not found elsewhere, but it's not that different. And these extra skills, for example, are being able to strictly stick to your role and to force yourself to stop your instincts. Well, in some cases at least. I've had this situation when, say, I was with a client, I was with a witness, and the witness in the beginning said, so it started as usual. I interpreted into Ukrainian, but then the witness said in Ukrainian to me, no, thank you. I speak English, so I don't need interpretation. And please just be on standby in case I need assistance. So I interpreted that the client is saying exactly that. And I was on standby nearby, which is difficult. So it's another skill to be always on standby,
Yeah.
to be ready to help, but not doing anything. It sometimes we're not trained for that, and it requires an extra skill. But then at some moment, the witness just having heard the question, they asked in Ukrainian, um, so this specific English term, what exactly does it mean? And I was already kind of a bit tired because it was like the second hour, and I just responded in Ukrainian. So I interpreted the word which I heard, which I was asked, but I didn't explain it in English to the judge. And then I was frowned
Mhm.
upon, and they said, "So, what was the content of that exchange with the interpreter?" I said, "Oh, I apologize, my lord. So it's this and this," and of course it was fine. But sometimes you have to even stop your urge to help, to interpret, if you
Yeah.
have to if you have to interpret to the other person in the courtroom.
That's true. Actually, a couple of things that you've said have brought up a couple of little questions in my own head as well. One of them, you were saying, if you end up making them have this multi-million-dollar contract for engines instead of motors or whatever, that you bear the liability. So would you have an errors and liabilities insurance as a legal interpreter, or does that not exist?
It does not exist in Ukraine. I asked. It doesn't exist. I know it's there in Germany, and I would say if you are living in a country with a strong litigation culture, you definitely have to get one. It just helps. But in Ukraine, I specifically asked. We didn't even have a single case of the NDA contract enforcement. So I sign NDAs quite easily. Well, I read them anyway. I look into them, and
Yeah.
I don't subscribe if I don't subscribe. But it's much easier to sign any contract if you know that there's no case law on its enforcement. No one even tried to enforce such a contract in Ukraine. While in the US, it would be different. So
Mhm.
you have to know your market. You have to know the niche. But in
Okay.
general, I mean, insurance, you need insurance only as a really last resort. First of all, would you want to have a client with whom the risk is so high that you might get the insurance, that you might need the insurance? I mean, it's always easier to, first of all, to pick your clients properly, those who understand your worth and who, um, well, would not even want to hold you liable, because I mean, even the prospects of having the
Mhm.
interpreter liable for a huge sum, it would take many years, and why would they even bother? And the other
Okay.
thing is that your contract has to be worded properly so that you can always say, look, well, even if you allege that I caused the damages, well, the situation was such that mm, like you were a factor in these damages too. So anyway, it depends on the wording of your contract. You can always put some
Okay.
indemnification in the contract, and it would help avoid these situations.
Okay. And we can get back to that in a little bit because, as you know, we have a question on contracts coming up. I just wanted to let you know that we've got somebody here from Australia. It's 1 in the morning. Thank you so much for coming at this ungodly hour for you.
Wow. So okay. So
And
we
another
need
person,
we have Asia, Australia, Africa, North America, Europe. We need someone from South America. I hope I just um, I can't see anyone from
possibly,
South
I'm
America.
not sure.
Hopefully,
Not yet. Not yet.
Tunisia,
Maybe
Nigeria.
in the replay,
Hi.
if not. Yeah. So, oh dear, have you heard of any case when an interpreter was criminally liable for misinterpreting? Because that's what every court warns an interpreter about before the proceeding starts. And in fact, this person also had a comment, which is that in many countries, official court interpreters are not paid well, which is a problem, in most places, quite frankly.
It's true. So let me answer the second question first. It's true, and this is one of the reasons I'm not interpreting in Ukrainian courts. But the main reason is that I'm not eligible to interpret in Ukrainian courts because I have um, a, a degree in law, not in interpretation, not in translation actually, because the Ukrainian judge would need to see your diploma where it says that you are a translator of English and Ukrainian, and then they would say, okay, and now go ahead. Not even conference interpreter, not even interpretation, anything would go. So it's only the Ukrainian translation that needs to be in the diploma. So I can't. And uh, still, the workaround is that many clients in Ukraine, they know that well, interpreters in courts are not paid well. So instead of getting the court-appointed interpreter, they would just hire someone out of pocket, and well, the payment would at least be somewhat to the market level. So it's just one of the ways out. But well, this is only true if we talk about criminal cases. If we talk about commercial cases
Hmm.
and international arbitration and investment arbitration, this is where it gets interesting. Because if the parties in the dispute have millions or billions at stake, they are ready to pay to the interpreter as much as they pay all the paralegals in the case, and paralegals usually get enough. And the other question was about uh, the,
Liability.
the cases of liability. I've read about some of those. I think there was a case in Germany with a translator, in the UK with an interpreter. I don't remember the languages, but in all of the cases I've read about, it was like gross misconduct. They kind of, it was, the intent was clear. So I
Mhm.
remember that if the prosecutor wants to hold you accountable for misinterpretation, they also need to show the intent. So it's not
Mhm.
just the misinterpretation as such. They need to show that you had the intent, or it was gross negligence, not just negligence, uh, and that would be a crime. But I think in most cases,
Okay.
if you are as faithful as possible to the best of human abilities, then people just
Yeah.
understand that as a slip of the tongue is possible and it's natural, and nobody would hold you accountable for that.
Okay. Just to let you know, we have rounded out our globe. So we now
Brazil.
have Brazil.
Hey, hey, hey.
Okay.
Nice.
So, so that's good. So, let's see. So, another question that comes up often is legal interpreting more like verbal translations, or how faithful do you have to be? And I just remember one arbitration where I was hired by one of the parties, and I was sitting in the booth, and one of the lawyers, I think it was from the other side, came over and said, um, just say what I say. I don't want you to use any idiomatic expressions. And I'm thinking, how am I supposed to speak my language natively if I don't use idiomatic expressions? Okay, not pictorial, image ridden things, but how am I supposed to do this? But he obviously was somebody who had been bitten in the past by something where he didn't understand something or whatever. And he spoke both languages. So he was definitely following us very closely.
Well, I can imagine. I've well, it is somewhat linked to verbal translation, but as always, um, it depends. In especially, first of all, there are two major aspects. There's one thing when you interpret between two lawyers. In this case, you cannot be literal and verbal, because these
Mhm.
3D notions, they don't sometimes map verbally. So you have to establish this
Mhm.
link uh, notionally. And for example, when in Ukrainian it says notice of suspicion, in English I would use indictment, because if I tell the notice of suspicion to a US lawyer, they might not understand what that means, or they might have to induce the meaning. But anyway, you explain it as accurately as possible, but on the level of meanings. In
Mhm.
court interpretation settings, when you interpret for the judge and for the court, you are probably you sometimes you can't have as much freedom to go into the meanings, and it's a fine balance. You can't be all too verbal, especially with idioms. Like, don't translate the idioms. uh, i um, I once had a barrister asking a question. Well, you're lying, it's just red herring that you're proposing, isn't it? So I, in theory, I even know the Ukrainian idiom, which would be something similar like red herring, but as soon as I use it, it would be out of context. The client would say, "What?"
Mhm.
The witness or the suspect would say, "What?" And so, of course, I interpreted as, you are trying to confuse us, aren't you? Uh, so you have to be literal, but it doesn't mean like following the idioms literally. And if you can't, there's also a safeguard. So there's always a way out. You can say, as the saying goes, or as the Ukrainian proverb goes, it's this and that. And then you kind of earmark that it's a proverb, and you can explain its meaning. But
Mhm.
it's always a fine line. You don't have to be too long in the explanation. It has to be, essentially, I look at it in this way. So there's a train of thoughts that, uh, say, a witness is producing. So the judge has to have the
Mhm.
exactly same train of thoughts. And sometimes
Yeah.
the clients are even just speaking grammatically incorrectly, with incomplete sentences, with just a set of words. And sometimes it's all really clear. Even if it's grammatically incorrect for you, it's really clear what they want to say. In this case, you
Mhm.
interpret because it's clear, and you just say it like
Mhm.
that in a grammatically correct form. But sometimes you aren't sure. For example, they didn't use a verb, and then you can assume that they kind of went there or drove there, but you don't know. And whatever you choose in English, you would be narrowing it down. In this case, it's always better to ask. It's always better to stop, to ask, to rephrase the question, And this is one of the things which might be a distinguishing sign of a good interpreter. A good interpreter is not afraid to ask to rephrase or to repeat if they don't understand. If the interpreter just assumes that I can use any verb here because I want to keep the appearances, well, this could be sometimes fatal. But one shouldn't assume, and one shouldn't be afraid to ask to rephrase. The input has to be really clear for you, and then you can produce the output. This is what matters, not being verbal or literal as such. Yeah, there are, of course, schools of thoughts
So not
which say,
necessarily
yeah.
so not necessarily repeating things if they repeat them, or pausing and dropping things if they pause and drop things, so that you are an exact replica of them.
If it's, well, if you are able to get the exact meaning, then if you can also improve the form of it, that's even better. If there's if there's a false start of a sentence, if the client says, well, I went there, well, I drove there at certain hour, if you, and if the client says, if the client goes on for like 3 minutes, if at the end of those 3 minutes you can remember that there was a false start, and you would say, well, I went there, I drove there, it would be even better. But
Okay.
if you look at your recording and you only know and it's been really clear that the client was actually specifying that they actually drove there, it's enough to say exactly that. If you can add
Okay.
this thing, it's good. But the lawyers would have the transcript and they would have the recording anyway. If there is something really important that you missed in it, they would get back to it in cross-examination. I mean, it's not your problem, essentially. It's the lawyer's problem. You are being as faithful as possible to the meaning as such, and this is what matters.
And so you were saying interrupt and ask questions. So somebody is asking here, can the interpreter interrupt the judge? Is it possible?
Oh, well, the judge, I mean, I don't have that much experience with US legal system where the judge might be asking a lot of questions. In uh, well, it is possible. It's possible not to interrupt. I think interrupting is rude, but I would say
Asking for
asking
clarification.
asking to rephrase is certainly good. And actually, as long as you're helpful, as long as the judge sees that you are helping them getting their question to the witness, it's all fine. As long as you are not
Okay.
really being a pain in something, then it's fine. It's fine.
Okay. And what about things like swearing or different registers and things like that? Would you, if the person was either swearing or speaking in a very uneducated register, would you then interpret in that very uneducated register? Or would you interpret as you and explain or not?
That's another tricky thing. And first of all, there's a story I had. I talked to a person, a lawyer, whose job now is monitoring internet propaganda. And in some countries, the propaganda says just things which are, it's more than swearing, it's both pejorative and it's so complicated that it's difficult to put it into English, essentially. So I thought, okay, the interpreters in future criminal trials would probably have a hard time unless they get all those expressions translated previously, and they would have to have the list of pre-translated swear words and expletives and comparisons and idioms and whatnot. But in court, of course, I've had situations when the client, the witness, who was nice and polite at first, when the barrister just questioned his authority and his honesty, started being like hot under the collar and lowered the register slightly. Then, if I can, I would lower the register. I don't have any problem saying fuck in court, as long as this is what if it's the equivalent of what I've heard from the witness. But sometimes I realize like I don't really have all the linguistic tools, because I
Yeah.
I if my witness
Swearing is
starts
so
talking
different.
in criminal argot, in jargon, I and I had this case. It wasn't a witness; it was actually a lawyer in a training for the lawyers, who just used an idiom in very criminal jargon, and I said, okay, I interpreted the meaning, but I simply I couldn't find the form. Actually, the form was something like what's the it was another colleague later helped me find the exact form in the colonial um, language. It was slowly catchy monkey. So I, I
Okay.
I didn't know that idiom
Which is
first. So
incredibly pejorative and so on. So yeah.
it was as pejorative in English as the original was in Ukrainian, but
Wow.
um, if I knew that, maybe I would have used that. But I didn't know, so I rendered the meaning. So it would embellish the
Okay.
form. If you can do it, then it's good for you. But you need to render the meaning as accurately and precisely as possible.
Okay. So I'm just thinking, quite frankly, that Russian swearing, which I know well, and English swearing, which I also know fairly well, certainly do not map to each other in any very easily.
I've I've had
We're
this
not going to
in
have no. We are not having a discussion on swearing now.
no. It's not about swearing. It's about theater. Once I was interpreting
Mhm.
in theater, where after the performance, after the opening, it was a British show in Ukraine, and there was also the director, the Ukrainian director. After that, who came on stage and talked to the audience, and there was a whole discussion whether English words are allowed in theater and whether Ukrainian um, swear words are allowed in theater.
Mm,
And they're different. I would say that the equivalent of Ukrainian or Russian swear words would be racist, like racial slur or something. The level of
sometimes,
taboo
yeah.
would be
Yeah,
like that.
yeah, that makes
But
sense.
let's get back to legal
That makes sense.
interpreting.
Okay, we'll do a different show on swearing at some point, maybe,
Okay.
maybe. So, what if you are hired to do some kind of legal interpreting, wherever that may be? What should you not saying that you will, but what should you receive from the parties if you're hired?
You should always ask for as much context as possible. Because if
Mhm.
the barrister, if the attorney is asking a question knowing some context, they, I mean, you have to have that knowledge too, ideally. So you are asking for the pleadings, for the statement of the case, for the counterclaim, and for all other documents you can get. In major cases, they have the list um, of entities, the dramatis persona, and sometimes you get skeleton arguments. Actually, I had a case where I received skeleton arguments of the parties, and you try to get the glossaries. Sometimes the parties agree, especially in international arbitration, they agree on
Yeah.
a glossary. And then even if you disagree with a term there, you still use it because it's agreed by the clients. So you have to ask
Mhm.
for as much as possible, and it takes time to read all that, and it has to be covered by the reading in fee, and it is hourly usually. So the average ratio is about 20, maybe 30 pages per hour. You probably can't read more thoroughly because you're not only
No.
reading, you're making a glossary, also you're thinking, and you're writing out the names to be able to use them properly. And if it's Ukrainian or Russian or
Mhm.
I mean, you also have to Google the patronymics to be able to address the person in first name and patronymics
Yeah.
instead of just the first name and last name, because it's the
Mhm.
way to do it, and it shows
Mhm.
class. It if you and actually it would be probably better to interpret the question if uh, the prosecutor says, "So, Ivan Petrenko, what do you think of this?" You should say, "So, Ivan Ivanovich, what do you think of this?" Because it would be the meaning which was put in that in the question,
Mhm. Mhm.
and you get as much as possible. You might not get everything, and then we get back to the question of liability. If someone
And then we get to
later
and then we get to our next question, which is about the
Mm.
contract to make sure that we cover the liability. See, we've got it all planned out.
So, if you don't have everything which you need for the context, and if later the client says, "Well, you misinterpreted that question," you can always respond, "Well, I didn't have all the context. I didn't
Mhm.
have all the knowledge of the case you have had when you asked the question. So I couldn't choose the proper equivalent because because I was provided only the witness statement and nothing else. I didn't know the case, the claim, the counter claim. I didn't know much, and that's why the best words. I know that some people say that you have to look into the wording of the oath, but it's difficult to change the wording of the oath. It probably is only allowed in arbitration. Uh, I once had a situation when it was in arbitration when the tribunal only at the end said, "Oh, did the interpreter take the oath? Oh no. Okay, but were you honest?" I said, "Of course, I interpreted to the best of my abilities as faithfully as possible." "Okay, so it counts as an oath." So it was like a post factum oath, or affirmation rather. But
Mhm.
essentially, instead of thinking of the oath, uh, we, and thinking of the criminal liability, it's better and probably it makes much more sense to think of civil liability to your client who hired you for damages. And in this
Mhm.
case, the best wording you might have, it's not only to the best of human ability somewhere in the beginning where you're providing the interpretation services to the best of human ability, but also somewhere closer to the end, the words "to indemnify and hold harmless." This is very important also. You have to explain to the client in the contract, in writing, what exactly is it that you need for good interpretation. If it's remote interpretation, you have to put in writing which exactly headsets are required, what should be the frequency range of the microphones, that it should be a wired headset, not the Bluetooth. Essentially, you have to put a condensed version of the ISO standard there, or you can put a direct reference to the ISO standard. And then there are two ways out of it. One, like if the client agrees, then you can say, okay, and then there's also a 20% surcharge if you fail to provide any of that. and the client would say, well, but why the surcharge? And that then you respond with, but wait, are you intending to kind of, I hope we agree that you will provide all of that, and it's just a deterrence, it's just a precaution. It's I'm sure it's nothing. You would provide all that, wouldn't you? And the other way, if the client would say no, 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 if it's difficult to negotiate, then um, you just say, okay, in this case you indemnify me, and if I mishear anything because you are not using the headset, then well, you hold me harmless. And i I learned this essentially, I must say that I learned this from Viktor Prokofiev, who is fantastic at drafting contracts and at interpreting in legal settings and legal environment. So it's very effective, and it is really useful. Sometimes uh, in courts, I mean, if there are, especially if there are many attorneys and barristers, sometimes not all of them wear headsets. If it's a remote hearing, sometimes they say, okay, I don't want to be restricted, I want to be able to get my the bundle, I don't care. But then it's only one out of many, and if at least the witness and the judge are having the headsets, then already it's good for you. And same
Mhm.
for the all the preparation and the reading in materials. If you don't have all of that, then you can always refer to that. You can say, well, look, it's well, you're in breach of contract. It depends on the wording of the contract, but you are in breach here. You said that you undertake to provide me with everything, and you haven't. So, well, it might help you get away if the client is trying to underpay you or something. But I mean, it's better not even to get into these situations. It's always good to be protected by the contract. So you should always have it, especially with lawyers. It's always better to be explicit and to have everything in writing. Uh, any negotiation has to be in writing, at least in emails. But after all, if you're doing a good job, if they see what you're, if they see the worth you're bringing, then I don't think you'll have any problems, and you will never have to enforce that.
Oh, I have had a contract which had everything in it, including a reading in fee, questioned after the case was over by one of the lawyers saying, "We're not going to pay that." And I said, "Well, you're going to because you've signed the contract and it was in the contract. And so, obviously you will pay it." And they did, but they kicked their heels a bit ahead of time, which was, I found, quite bad behavior on their part. So,
It happens,
okay.
and uh,
Yeah.
I can just say that it happens, but sometimes it's just part of the natural way of business, and there's nothing personal. So sometimes they just have to um, pay unless they are threatened by a claim so unless you say that,
Mhm.
well, if they don't pay you now, you will take this to this small claims court, and only then they pay. It happens, and just don't take it personal. This is what lawyers sometimes do, but of course good law firms,
Yeah.
they pay you immediately.
Yeah. So Chiara writes, I like the idea of the 20% surcharge. Well thought out, Andre. And um, Darjan says courts usually don't provide any documents at all, which is true. When I worked in the Washington, D.C. courts, they never gave us anything whatsoever to prepare with.
And then
So,
it's much more
yeah,
difficult. So I can say that the
yeah,
work of court interpreters who are hired by courts is much more difficult. But then the only way out would be to come together in an association and to explain it to courts. I mean, there should be some collective bargaining. I think. Well, this is the only way to do it,
I think
and
I think at
Canada
the
has
moment,
good experience here. Mhm.
yeah, I think at the moment, collective bargaining is going to be focused more on getting fees that are actually livable as opposed to getting the information that they need at this point. I mean, pick your battles, but
Yeah.
it's true that without that context, it's extremely difficult. I mean, I worked in the DC courts for a little while, and I swear, criminal court for me, never again. It was no information given. Somebody's fate depends on how I'm interpreting when I'm not given any information at all. And I preferred conference. It was a lot less fraught, even when I was sitting across a negotiating table from, and interpreting some heated negotiations. It was still less fraught.
I watched a webcast of a criminal trial in Ukraine last year, where the interpreter had to essentially lean across the bench all the time to whisper to the accused, and it was the interpreter was in this shape all the time. It was so uncomfortable, but they couldn't get into the box because the box was all behind the bars, so they only had to lean to whisper. It was horrible, and I just well,
Yeah.
it's not easy. And interpreting when you are hired by courts in criminal cases, it can be kind of mm, it can be morally gratifying that you are helping people and it matters, but it's very difficult usually. That's true.
Yeah. Yeah. That can very much um,
Oh,
be so
Estonia,
to that.
the court shares all the documents. So I mean, if you're in Washington, you can always say, "Look, Estonia, they have this fantastic system. They
Yeah.
do share the documents." Like, so you can always use best
It's
practices, and you can always learn
it's
from other
true.
colleagues.
In fact, everybody who's on this call now and who can see this show at some point, you should all get together and start sharing best practices so that you can point to each other and say, but Estonia does this when you're in Washington, or but Washington does this if Washington does something better in Estonia, and so on. So, please feel free to use the comment section here as a platform for that. Okay, our last question, actually our next to last question. How do you break into legal interpreting? And I know you've got a bit of a story on that one.
Mhm. Yeah, this story is that I have a degree in law. I worked in a law firm for one day. At the end of the day, I said, you know what? I make better money translating, and I know that I might get something better at the end of my career, but no, thank you, not today. And I never worked as a lawyer ever again. And then I started doing all the translation and interpretation work, and I was thinking about legal interpreting, but I never had a chance. And like I wasn't allowed to interpret in courts in Ukraine because I don't have a diploma as an interpreter. Until like one day, I think it was an agency who said, "Oh, we have a law firm as a client who need an interpreter with a degree in law," and they said, "Okay." So I was there. I didn't know anything. I didn't have any documents. That was my first experience, and I thought that it would be like a conversation with an attorney in the office of the law firm. And I was there, and they said, "Okay, so we have a trial in the U.S. and we have to dial in remotely, and you will interpret for the claimant." I said, "Well, okay. So where's the Jabramik? Where's the setting?" They said, "No, it's your Nokia phone. You phone the court." So I had to dial in. I had to say, "Okay, hi, I'm an interpreter," and then it was tricky because in the hearing they said, "Okay, but we can't hear the actual words of the claimant." So I had to give the phone to the claimant. Then I had to interpret what they said. They had to. I mean, it was it was really strange, and it was my first experience, and it helped in the CV later. So I would say to break into legal interpreting, you sometimes have to be lucky, and luck mostly comes from networking. What really helped me was attending CCIC, where I met another legal interpreter who introduced me to other legal interpreters, and this is how it started. So CCIC is a fantastic way not just to improve your conference interpretation skills with best interpretation teachers ever, I would say, but also it's a fantastic way to network, and that's true. So, but it's good for me because I mean, I had this background in law, so already had some skill. I still had to improve, I still had to learn, but I had some background in it. And it's like
Mhm.
in health interpreting. I have a colleague who is an MD, he's a doctor, and I hate that
Mhm.
he almost never prepares. Like it takes him, I don't know, half an hour to prepare to a conference. He just browses the slides and he says, okay, okay. And I had to spend like 3 days to prepare to the conference. So I realized that if you don't have a degree in law, you don't have to have it. There are fantastic interpreters, legal interpreters without any degree in law, but they prepare and they uh, actually read into, well, all the case files. And if it's not just commercial litigation or arbitration, if it's, especially if it's interpreting uh, lawyer speak for lawyers, they read into the
Mhm.
codes, they read into actual documents, actual sources of law. And this is why I
Mhm.
am now kind of starting this side project of the Ukrainian glossary, because the official translations of many international treaties in Ukrainian are obsolete and bad and inconsistent, very inconsistent amongst the different international treaties, so we have to standardize it somehow. But you have to actually read
Mhm.
it, even though I have a degree in law, I still have to read all the source documents, because I need to know the
Mhm.
exact wording used right there. And
Yeah.
sometimes the equivalent is just not there at all, and then you have to ask other lawyers, which is a fantastic way to get attention. If you want to be noticed as a legal interpreter, start talking to the lawyers about linguistic matters, about what would be the best way to interpret this and that, and most probably you would be noticed, you would get attention, and you would improve your skills in law and linguistics. This it helps it and listen to the podcasts, or read the text, attend the conferences in the sphere of interest for you. And just sometimes people have this imagination that if they go to a conference of lawyers and they say, I'm an interpreter, then they would start just giving the business cards and would say, okay, we need an interpreter. It doesn't work like that. You have to just, you go to conferences to get to know interesting people to whom you might ask a question about a legal term. And then later, if they need an interpreter, they might someday in 5 years say, okay, there was this interpreter, let me see who they are on LinkedIn and so on. So
Yeah.
it's a long shot. Sometimes I
It's a
had
long
clients,
day.
yeah, but it matters. And like
Mhm.
I am interested in international criminal law, and that's why I adore this podcast, Asymmetrical Haircuts. I really,
Mhm.
it's so great. It's both interesting and it's about criminal law, international criminal law in particular. Highly recommend it.
Mhm. Okay. Well, thank you. I think we're going to stop there because in this last answer, you actually answered the other last question we had,
Oh,
which is it better to have a law degree or not? Or is it better to be a lawyer linguist? Or is it better to be an interpreter who prepares? But I think you've just answered that. So before we get to today's top tip, which is a bit late, I have to say, and I am a little sorry, but it was a really interesting topic. And Andrii had a lot of really interesting things to say. So before we get to his top tip, I just wanted to let you know that our next show will be on May 6th, also at 4 p.m. It'll only be about half an hour because it's only going to be me for a change, not with a guest. And it will be an AMA focusing on branding. And the reason I say that is because people have asked me lots of questions about branding, throughout the last few years. And so if you have any specific questions about branding, please send them on in ahead of time so that I can get the show prepared. Along with that, I'd like to let you know about an opportunity for continuing professional development, which is something that Andrii just mentioned. And thank you so much. No, I am not paying him. But the Cambridge Conference Interpretation course is open for enrollment. Our working languages this year are English, French, German, Italian, Spanish, and Russian. And so if you have any of those languages, please take a look at our website. I'll put that down in the comments below this, as well as Andrei's favorite podcast and a couple of other bits of information. So today's top tip, and let me just bring up the banner for that. Andrii, the floor is yours.
Do not assume. Ask for clarification. If anything is not clear, just do not assume you understand if it's not clear. This is actually a sign of a good interpreter, is if you ask for clarifications.
Mm-hmm. Excellent. So thank you very much, Andrii. And you can see that we have a lot of thanks coming in, and people have been very happy about what you've been able to tell us. And thank you for the podcast as well. So that's really great. And we will see all of you. Well, I will see all of you in a month, I hope, fingers crossed. Hopefully this cold will be gone. And Andrii, good luck with your glossary, and good luck with the work and the legal work, because, oh my God, I can't imagine the amount of work you have at the moment. And we hope to see you around on the internet and on LinkedIn quite a bit.
Thank you so much.
Thanks, everybody, and goodbye. See you next month. Sorry, I'm just clicking all over the place today.